All right, so welcome to the deep dive. Today, we're going to be diving into workers' comp in California. And we've got a ton of legal documents to try to unpack all this stuff for.
Right.
So, I hear that California is pretty interesting because it's what they call medically driven.
That's right.
So, what exactly does that mean?
Well, it means that doctors play a really big role in the whole legal process,
Oh, really?
more than people might think.
Okay, so it's not just about lawyers and courtrooms then.
Not at all.
This is fascinating. So I've heard all sorts of crazy things. Can you really get workers' comp for a paper cut?
Well, it depends. A paper cut, a splinter,
Okay.
those kinds of things. Legally, they fall under first aid. So if it's a one-time treatment
Mm-hmm.
and observation, it's probably not a workers' comp issue. But
Right.
if that paper cut, say, gets infected
Oh, okay.
and it requires, ongoing care, then we might be talking about something different.
Okay, so there's a line there. It's not just any little scratch. Now, what about those aches and pains that build up over time?
Yeah.
My lower back is killing me from years of sitting at this desk. Can I blame my employer for that?
You actually might be able to.
Really?
Yeah, that's where the concept of what's called cumulative injury comes in.
Okay.
California law recognizes that, Injuries don't always happen in a single, dramatic event,
Mm-hmm.
repetitive strain,
Hmm.
like from lifting heavy boxes or even
Mhm.
sitting with, bad posture. All of that can lead to real injuries, compensable injuries.
Hold on. So you're saying my bad back could be my boss's problem,
It could be.
even if it's been years?
It's possible.
That's pretty wild.
But it's not always a slam dunk.
Okay.
You'd have to prove that your work was a major contributing factor to the injury.
I see.
And that's where doctors come in. Their reports can be crucial in establishing that link between your job and your pain.
So it's not just about convincing a judge that you're hurting.
Right.
You need medical evidence.
Exactly.
Okay, this is way more complicated than I thought. What are the key things then that someone needs to prove to make their case?
All right. So there are four main conditions that have to be met. First, there has to be an actual injury.
Okay.
Could be physical,
Hmm.
could be psychological.
Got it.
Second, there needs to be a clear employment relationship.
Okay, so I can't sue my neighbor
Right.
for making me rake their leaves.
Exactly.
No matter how bad my back feels.
No matter how bad your back
Makes
feels.
sense. So what are the other two?
The big ones,
Okay.
what we call arising out of employment, AOE for short,
AOE.
and occurring in the course of employment, or COE.
COE.
Proving these can get tricky.
Okay, those sound a little jargony to me. Can you break them down?
Yeah, absolutely.
Yeah.
What's the difference?
So imagine you're a delivery driver, right?
Yeah.
And let's say you hurt your back lifting a heavy package into your truck.
That would be AOE. The injury happened because of the work you were doing. Now, let's say you slip on a wet floor at the company warehouse and break your wrist.
Okay.
That would be COE. The injury happened at work, but not directly because of the work itself.
Okay, I think I'm starting to get it. So if I tripped over my own 2 feet
Uh-huh.
in the office kitchen, sprained my ankle, that could still be covered,
God.
even though it was my fault.
As long as it happened, what we call in the course of employment,
Mm-hmm.
meaning while you were on the job
Mm-hmm.
and doing something, even indirectly work-related, it could fall under workers' comp.
Okay, so even grabbing coffee down the street
Yeah.
could be considered
That's correct.
in the course of employment. That seems pretty generous.
It can be, but
Oh.
there are limits, of course.
Okay.
Let's say, you decide to go for a jog in the park
Oh,
on your coffee run and trip and fall while you're jogging. That's
Jogging.
probably not going to be covered.
got it.
It's all about the circumstances
Mhm.
and whether the activity was reasonably related
Yeah.
to your job.
Okay, I'm starting to see how this gets complicated.
Yeah.
So it's not just about proving you were injured at work.
Right.
You need to show how the injury is connected to your work,
Exactly.
either directly through the tasks you're doing or through the circumstances of your employment.
Exactly. And remember, even with those indirectly related injuries,
Yeah.
the judge ultimately decides whether it's workers' comp or not.
Okay, it's not a guarantee.
It's not a guarantee.
So we've got injuries, AOE and COE. What else?
Well, there's another crucial piece of the puzzle,
Okay.
the date of injury, or DOI.
Okay. Why is that so important?
Well, let's go back to your bad back for a minute.
Okay.
You said it's been building up for years, right?
Right, yeah.
But when did you first realize that it was related to your work?
That's a good question. I mean, it's been nagging me for a while, but I only recently started to connect the dots, probably a few months ago. when my doctor started asking me about my, work habits.
And that, my friend, is likely your date of injury, not when the pain first started.
Wow, really?
Yeah. California law says that DOI, for these cumulative injuries, is when you first became disabled, and he knew it was work-related.
So even if I've been suffering for years,
Uh-huh.
the clock starts ticking. When I make that connection
Exactly.
between the pain and my job, that seems like that could be a problem
It can be.
for people who don't realize what's
Yeah.
causing it right away.
Absolutely. That's why it's crucial to keep good records
Okay.
of your symptoms, any medical treatment you receive, the tasks you perform at work. If you start to notice a pattern, don't wait. Speak up.
Okay.
The sooner the better. So you're protected if you need to file a claim later.
That's really good advice. So we've got injuries, AOE, COE, date of injury, my head spinning. What else is there?
Well, there's a whole other layer of complexity when it
Uh-huh.
comes to certain professions, especially first responders.
Oh, right. Firefighters, police officers. I've heard they have some special protections.
That's right.
Under workers' comp. What's that about?
That's where what we call presumptions come in for certain professions.
Yeah.
Certain conditions are presumed to be work-related, which shifts the burden of proof to the employer.
Interesting.
So, for example, if a firefighter develops heart disease, it's assumed to be a result of their work, unless the employer can prove otherwise.
Wow, that seems like a big advantage.
It is. It acknowledges that their work inherently exposes them to certain dangers.
Yeah.
And it streamlines the process of getting them the benefits they deserve. If those risks materialize,
Okay.
of course, the employer can still challenge the presumption, but it's a significant benefit for these workers.
Makes sense. Now, what about mental health? When does stress or anxiety become a workers' comp issue?
That's a great question. It's definitely not as simple as just feeling stressed or unhappy at work.
Okay.
California has some of the toughest standards in the country when it comes to these kinds of claims.
Really?
You have to prove that work was the predominant cause
Dominant cause.
of your mental health condition.
What does that mean?
It means that work was responsible for more than 50%
More than 50%.
of the problem,
Oh, wow.
considering all potential factors. So if you're going through, a tough divorce or your dog just died and your boss is a nightmare, it's going to be hard to prove. That work was the main driver of your anxiety.
Okay, so basically my boss just has to be really bad.
Well, documentation's never a bad idea. But realistically, proving a psychiatric injury is very challenging. There are some exceptions, of course.
Okay.
For example, if you witness a violent act at work or experience some kind of traumatic event on the job, the threshold for causation might be lower.
Okay, that makes sense. What about getting fired? That can be really stressful for some people.
It can, but unfortunately, in most cases, no. Getting
Right.
fired or laid off generally is not considered a valid psychiatric injury
Wow.
under California law,
That's surprising.
unless there were some truly extraordinary circumstances leading up to it.
I see. So the law is trying to prevent people. This is all so fascinating.
It is a complex system.
We've covered injuries, AOE, COE, date of injury, special presumptions, psychiatric injuries. This is a lot.
Yeah, we've covered a lot of ground.
Is there anything else we need to know?
Well, there's still plenty to unpack,
Okay.
but I think we've laid a solid foundation so far.
Great. Well, let's take a quick breather, and then we'll dive back in.
Sounds good to me. All right, are you ready to jump back in?
Oh, yeah, absolutely. I feel like we've only just scratched the surface here. You mentioned earlier that there are, different types of injuries. What about those illnesses that you get from work, like from chemicals or
Yes.
loud noises? Are those covered too?
Yeah, you're talking about what we call occupational diseases.
Okay.
And yes, those are definitely covered under California workers' comp. Think of it like this. An occupational disease is any illness that's caused by the work you do. So it could be lung disease from breathing in dust all day, hearing loss from working in a noisy factory, or even skin problems from handling certain materials.
So if I develop carpal tunnel from years of typing at my computer,
Exactly.
that would be considered an occupational disease.
That would fall under the category of a cumulative injury,
Right.
since it developed over time.
Right.
And remember those 4 conditions we talked about earlier?
Uh-huh.
Those still apply. You'd need to show that your carpal tunnel was caused by your work,
AOE.
AOE,
Ah.
and that it occurred during your work COE.
COE. Right. Okay. So it all ties back to those same principles.
The guys.
But how do you actually prove AOE and COE? Like, what kind of evidence are we talking about?
Well, it depends on the type of injury.
Okay.
For a specific injury, like that slip and fall we talked about in the warehouse. It's often about just connecting the dots. Doctors will describe the incident in detail based on what you tell them. And they'll explain their medical findings. So if you fell off a ladder and broke your leg, the doctor would document how the fall happened, the type of fracture, and anything else relevant to your treatment.
So it's all about painting a clear picture for the judge.
That's right.
This is what happened. This is the injury. This is how they're connected.
Exactly. Now, with cumulative injuries, though, it gets a little more complex. Doctors need to really dig deep to consider all the potential factors involved, both work-related and non-work-related. They'll look at your job history, the specific tasks you do, how long and how intensely you're exposed to certain risks, and any pre-existing conditions you might have.
So the doctors really have to play detective a bit.
That's a great way to put it.
Piecing together all the puzzle pieces to see if work played a significant role.
Yeah, it's a very analytical process. Yeah. And it requires doctors to understand not just medicine, but also the legal side of things.
So if a doctor says, yep, this injury is definitely work-related, does that mean you automatically win your case?
Not necessarily.
Oh, okay.
Remember, the judge has the final say. The doctor's report is a crucial piece of evidence. But it's not the only thing the judge will consider.
Okay.
They'll also look at your testimony, any witness statements, company records, anything else that helps them determine the validity of your claim.
Got it. So the doctor's opinion is super important, but it's not a guaranteed win.
Right.
Okay, what about those psychiatric injuries we were talking about earlier? You mentioned California has, like, really high standards.
They do.
For those. What are some specific things someone would need to prove?
Well, first and foremost, you need a diagnosed mental health condition that's causing you disability or requiring medical treatment.
Yeah.
We're talking about things like anxiety, depression, PTSD, conditions that are impacting your ability to function.
Right. So it's not just feeling a little stressed out. It has to be like a real diagnosable thing.
A real diagnosable condition, that's right.
Okay, and then what?
Then you have to demonstrate that work was the predominant cause of that condition.
There's that phrase again, predominant cause.
Predominant cause.
So that means work is responsible for more than 50%.
More than 50%?
Of the problem. So it's not enough to just say, my job is making me anxious.
That's right.
You have to show that it's
the main reason.
The main reason, more so than anything else in your life.
Oh, wow. Okay.
And that can be extremely difficult to prove. But like I said, there are exceptions.
Okay.
If you witnessed a violent act at work or experienced a traumatic event on the job, the threshold for causation might be lower.
Okay, that makes sense. Are there any types of psychiatric injuries that California specifically excludes?
There are. And one of the big ones is claims filed after you've been notified of a termination or a layoff.
Really? So if I get laid off and then start feeling anxious or depressed, that wouldn't typically qualify.
Unfortunately, that's right. It's a tough rule. But the law is trying to prevent people from claiming workers' comp for emotional distress. That's primarily caused by job loss, rather than the work itself. Okay. Of course, there are exceptions, like if you were the victim of harassment or discrimination at work, and those events led to your layoff. But in most cases, the stress of losing your job isn't going to be enough to qualify for benefits.
I see how that rule could be kind of controversial.
There definitely is a fine line there.
Yeah.
And it highlights the importance of understanding the nuances of this system.
All right, so we've talked about different types of injuries, AOE, COE, the date of injury, psychiatric injuries. What else do we need to know? Is it just like one size fits all?
Not at all.
Okay.
The benefits you receive can vary depending on how serious your injury is and whether you're able to work.
So there are like different levels of benefits.
That's right.
How does that work?
Think of it like a spectrum of disability.
Okay.
On one end, you have temporary total disability,
right,
where you're completely unable to work for a period of time. Okay, so like if you break your leg.
Yeah, if you break your leg and need a few months to recover, something like that.
Okay, what about the other end of the spectrum?
On the other end, you have permanent partial disability, where you have some lasting limitations.
Yeah.
But you can still work in some capacity.
So like maybe you injured your hand.
Yeah.
And you can't do certain tasks anymore.
That's right.
but you can still perform other job duties. So the type and amount of benefits you receive really depend on how much your injury is impacting your ability to work.
Exactly. And guess who plays a key role in determining that level of disability?
Let me guess. Doctors.
You got it.
I'm starting to see a pattern here. Doctors are really central to this whole thing.
They are.
They're not just treating injuries, they're basically like gatekeepers.
That's a great way to think about it.
For the whole workers' comp system, this has been so informative. I feel like I'm finally starting to understand this. What advice would you give to someone who's like navigating this for the first time?
Well, the number one thing is to report any potential work-related injury or illness
Okay.
to your employer
God.
immediately.
Yeah.
Don't wait. This protects your rights
Good.
and ensures you get timely medical treatment,
Okay.
which is essential for building a strong case.
Okay. What about legal advice? When should someone call a lawyer?
Well, if you have any questions or concerns about your claim, especially if it's denied, or you're facing challenges getting benefits, I highly recommend consulting with an experienced workers' compensation attorney. They can be your advocate and help you navigate this complex system.
So it sounds like having someone in your corner
Yeah,
who knows the ins and outs of this can really make all the difference.
it absolutely can.
All right, so to recap, what are the key takeaways about workers' comp in California?
First and foremost, it's a complex system.
Okay.
There are specific rules and procedures
Yep.
that you need to understand, both as a worker and as an employer.
Right.
And those rules can be pretty nuanced, especially when it comes to things like AOE and COA. And don't forget the crucial role of doctors in virtually every aspect of this.
Yeah, it's amazing how much power they have in this whole process.
It is. And finally, remember that you have rights
Okay.
if you've been injured or become ill. As a result of your work, you may be entitled to benefits. Don't be afraid to seek legal advice if you need help navigating this system.
That's great advice. Knowledge is power, right?
It is.
The more you know about your rights
Yeah.
and responsibilities, the better equipped you'll be to advocate for yourself and get the support that you deserve.
Exactly. And remember, workers' comp is a no-fault system,
Okay.
meaning you don't have to prove that your employer was negligent to receive benefits.
No. Even if I was being a total klutz and
Yeah.
tripped over my own 2 feet at work.
You could, as long as that happened in the course of your employment
Yeah.
and wasn't caused by something like intoxication or horseplay.
Okay.
The point is, if your injury arose out of and occurred in the course of your work, you have the right to file a claim, even if it was partly your own fault.
Yeah. That's good to know. I'm wondering what happens if there's a disagreement between like doctors. Like let's say one doctor says my back pain is work related and another doctor says it's just age related wear and tear.
That's a great question.
How does that get resolved?
That happens more often than you might think when you have
Yeah.
those conflicting medical opinions. The judge ultimately has to weigh the evidence and decide which doctor's opinion is more credible.
Okay.
They'll consider the doctor's qualifications, how thorough their exam was,
Yeah.
and how strong their reasoning is.
So it becomes like a legal battle of the experts?
You could say that,
Mm-hmm.
and that's another reason why having a skilled attorney on your side can really make a difference. They can help you present your medical evidence effectively and challenge any opposing opinions. They know how to build a strong case and advocate for your rights.
This has been incredibly eye-opening. I feel like I've learned so much about the workers' comp system in California. Any final thoughts before we wrap up?
I would just reiterate that workers' compensation is a complex area of the law,
Oh.
and every case is unique. If you're dealing with a potential work-related injury or illness, it's crucial to seek guidance from both medical professionals and legal experts
Okay.
to ensure your rights are protected.
So it sounds like you really can't go it alone. With workers' comp, you need medical and legal expertise
That's right.
on your side.
It's a team effort. And remember, workers' comp is designed to protect both employees and employers.
Okay.
It's not about pointing fingers or placing blame. It's about making sure that people who are injured or become ill
Mm-hmm.
as a result of their work receive the care and support they need to recover and get back on their feet.
Okay, so it's about finding like a fair resolution for everyone.
That's right.
I've been thinking about something you said earlier about documentation. You mentioned it's important to keep good records of symptoms and work activities.
Right.
What if I didn't? What if I was, experiencing pain, but I didn't, like, connect it to my work right away?
Well, unfortunately, it can hurt your chances of getting benefits.
Really?
Remember, that date of injury is crucial,
Uh-huh.
and it's based on when you first became disabled. Indeed knew it was work-related.
Okay.
If you wait too long to report your symptoms or to seek medical treatment, it can be harder to prove that your injury is actually work-related.
So if I'm feeling pain or
Yeah.
noticing changes in my health, I should just report it.
It's always better to err on the side of caution
Okay.
and report it.
To my employer, even if I'm not sure if it's work-related or not.
Absolutely. It's always better to be safe than sorry.
Yeah.
Reporting those symptoms early on creates a paper trail and allows you to start gathering evidence
Okay.
just in case you need to file a claim later. Plus, it gives your employer the opportunity to address any potential workplace hazards
Okay.
and prevent further injury.
So it's about protecting myself
Yeah.
and a D potentially, protecting others from getting hurt. Now, I'm curious about something else. We've talked a lot about how doctors play a central role in determining causation. But what if there's like a disagreement between doctors?
Sure.
Like one doctor says, my back pain is work-related. And another doctor says, it's just like age-related wear and tear.
That's a great question.
How does that get resolved?
That happens more often than you might think. When you have conflicting medical opinions, the judge ultimately has to weigh the evidence and decide which doctor's opinion is more credible.
Okay.
They'll consider the doctor's qualifications, how thorough their examination was, and how strong their reasoning is.
So it's like a legal battle of the experts.
Exactly. And that's another reason why having a skilled attorney on your side is so crucial. They can help you present your medical evidence effectively and challenge any opposing opinions.
Okay.
They know how to build a strong case and advocate for your rights.
Wow, this deep dive has been so informative. I feel like I've gained a whole new understanding of workers' comp.
That's great to hear.
Any final thoughts?
I would just emphasize that knowledge is power. The more you know about your rights and responsibilities under the workers' comp system, the better equipped you'll be to navigate this process and advocate for yourself.
Okay.
Remember, there are resources available to help you, including medical professionals, legal experts, and even online information from trusted sources.
Great.
Don't be afraid to reach out for help if you need it.
That's great advice. It's all about being informed and proactive. And remember, workers' comp is designed to be a safety net for employees who are injured or become ill because of their work.
Right.
It's not about pointing fingers
Yeah.
or placing blame. It's about making sure that people receive the care and support they deserve to recover and return to a productive life.
Well said.
And on that note, I think we've covered a lot of ground today.
We have.
This has been an incredibly insightful deep dive into workers' comp in California. Thanks for joining us on this journey. And remember, stay informed, stay safe, and always advocate for your rights.